Do you even need a revocable trust? Hi, I'm Sabrina Winters. I'm an estate planning and probate attorney in Charlotte, North Carolina. If you want to talk about estate planning and probate, visit our website at sabrinawinterslaw.com. You'll find great information there, and also make sure to schedule your appointment right there online. Do you even need a trust? Well, in order for me to really properly answer that for you, I want to give you a little bit of background. Everybody needs to have something in writing in order to distribute your assets when you pass away. What you personally decide to choose is based on multitude of factors. When somebody is deciding whether they prefer to have a will or a trust, it depends on what you are trying to accomplish. If you are looking for keeping privacy over your assets after you pass away, if you're trying to get your assets to transfer quicker, if you're trying to keep the legal fees down to your estate later, and if you're trying to avoid a very long, tedious, complicated process, then the revocable trust is probably your option. Let me take a minute to compare what a will and a trust are, so that will help you kind of figure out what the best option may be for you. A will and a trust, pretty much the only things that they have in common are that you're putting in writing what you want to have happen after you die with all of your assets. It's essentially your rule book that those you've appointed are required to follow. What happens after you pass away completely depends on whether you had a will or a trust. On top of that, if you had a trust, it also depends on whether you took the proper steps after you signed your trust. If you have a trust, what you want to make sure that you're doing is the proper assets should be funding your trust. That means assets would come out of your name and into the name of your trust. Once you've done that, you've avoided probate over that asset. So for example, I took a checking account that was in my name and I transferred it into the name of my trust. Now I pass away. As soon as I pass away, my trustee named in my trust is going to distribute that asset the way my trust says it should be distributed. He or she doesn't have to get appointed to the court. Nothing needs to be filed over that asset in court. So all I've done with that one step is that I've avoided the long, cumbersome, tedious process of probate. I've kept a privacy over that asset so nobody can open a probate file and see what I have. An attorney won't have to make sure that everything has been done right, typically. And my beneficiary has my asset way quicker than they would have had it if I had a will and never named a beneficiary on it. It's important for you to know what your options are, but you won't know what your options are until you have a real detailed conversation with your estate planning attorney. They are the ones that should elicit from you, what are your fears? What are your concerns? What are your goals for what all of this looks like after you pass away? Recapping, if you want privacy, if you want assets transferred quicker, if you want to make sure that no one has to go through a long court process, then probably a trust is going to be the way that you want to go in order to plan your estate. But make sure you visit sabrinawinterslaw.com, schedule your appointment today, because tomorrow is not promised for any of us. Thank you.